Good afternoon to our viewers. Today's segment is all about family provision claims. Along with me in the background, I have McLaren's Lawyers Senior Partner Jessica Diop, who will be asking me a few questions on family provision claims.
What is a family provision claim, Dion?
So Jessica, when a person wishes to challenge a deceased's will for a share or a larger share from an estate, then an application must be made to the Supreme Court of New South Wales.
I see. And when must a family provision claim be filed to the court?
So Jessica, if a person wishes to carry out a family provision claim, it is important that they file the claim with the court within 12 months of the date of death. The court has a discretion to permit a claim commence outside this time, although special reasons need to be established.
Is everyone eligible to make a family provision claim?
So a family provision claim can only be made to an eligible person. In New South Wales, eligible persons are defined in Section 57 of the Succession Act 2006. An eligible person can include a spouse of the deceased, including a de facto spouse, or a person in a domestic relationship with the deceased at the date of death. It could also, an eligible person also can be a child of the deceased, a former spouse of the deceased, and a person who was dependent on the deceased during his or her lifetime.
When a family provision application is assessed, what will the court consider when assessing the application?
So Jessica, before the court makes an order, they usually consider surrounding circumstances such as the nature of the applicant and the deceased's relationships, any obligations or responsibilities owed by the deceased person to the applicant. So for example, Jessica, if the deceased supported the applicant in relation to the education, welfare or advancement in life, they can then come forward. They also look at how much the applicant earns and their financial needs. They also look at the applicant's personal details such as their age and their character. They look at whether the applicant has any physical, intellectual or mental disabilities, and the value and location of the deceased person's estate. And the list can go on, Jessica.
Thanks. I've heard family provision claims is a long and costly process. Is there another option before making a family provision claim?
So Jessica, unfortunately a family provision claim is a long process, and we encourage all parties to resolve their disputes through mediation. Mediation is an effective way to resolve disputes without going to court, and it can give the parties an opportunity to reach a settlement. You can save a lot of time, money and stress by settling your matter through mediation. So if you require any advice about family provision claims, please contact our Wills and Estates team at McLaren's Lawyers. Thanks Jessica.
Thanks a lot, Dion.
Thank you.